against the Secretary of State for the Home Department.
Mr. Laffer.
May it please your lordships and my lady, I appear for the appellant together with my learned friend Mr. Duran Seddon and Mr. Tim Iker and Mr. John Paul Wade appear for the Secretary of State for the Home Department. As the court may have seen, the Secretary of State has made an application to rely on further evidence, and if it's convenient from the court's perspective, since the application is proposed, I was planning on letting Mr. Iker make his application.
Well, I think we'll deal with this question of additional evidence when we've heard a bit of the case, if we may.
Well, as the court would have seen, the two main statutory provisions are Section 82, Section 84 of the 2002 Act. And if I may, I'll go to those straight away. In Volume 1, Tab 1, at page 12, the page numbers are on the top right. I'm so sorry, it's Tab 1, Tab 8, page 12. Right of appeal general, Section 82(1, where an immigration decision is made in respect of a person, he may appeal to the tribunal. 2, in this part, immigration decision means, then there are a list of immigration decisions, and the court is particularly concerned with H, a decision that an illegal entrant is to be removed from the United Kingdom by way of directions under paragraphs 8 to 10 of Schedule 2 to the Immigration Act 1971. And the other directly relevant provision starts right at the bottom of page 15, Section 84(1). An appeal under Section 82(1) against an immigration decision must be brought on one or more of the following grounds, and the court's particularly concerned with ground E, that the decision is otherwise not in accordance with the law. Now, focusing on these two provisions draws attention, in my respectful submission, to two aspects of the case. And the first aspect is how one reads Section 82(2)H. In particular, is the decision referred to in 82(2)H a relatively narrow decision, that a decision in principle that a person is to be removed from the UK full stop, as it were, or is it a wider decision that a person is to be removed from the UK in accordance with the removals machinery in powers 8 to 10 of Schedule 2 from the UK and to a particular country or territory? So that's the first aspect, the breadth of the decision in 82(2)H. And the second aspect is how one reads the appeal right under 84(1)E. Is the appeal right relatively broad and narrow? Is it an appeal in which all the usual public law grounds can be raised? And in particular, in an 82(2)H case, does it entitle the tribunal to determine whether the country or territory of removal, which is going to be set out in the decision notice, is one to which the appellant can lawfully be returned?
Are those different questions?
Well, I put it on the basis that there are two aspects of the issues before the court, and they are indeed, in my respectful submission, linked aspects. For example, if the court was to decide that the decision described in Section 82(2)H was a narrow decision in principle, as the Secretary of State submits, that a person is to be removed from the UK full stop, as it were, the court might still need to consider, in the light of Section 84(1)E, whether that decision, even on that narrow basis, was in accordance with the law, if, albeit that it's a narrow decision on this hypothesis, It was reached on the underlying basis that a person was to be removed somewhere where he can't lawfully be removed to. And our case essentially is that simple and short. We say, just to summarise our case, that a decision that a person is to be removed from the UK by way of directions under Paras 810 of Schedule 2 to the 1971 Act isn't in accordance with the law, that is, the Immigration Acts, Schedule 2, and public law, if it wouldn't be a lawful exercise of power under Paras 810 to remove the person concerned to the country or territory chosen by the decision maker. I said our case was ultimately simple and short. That's perhaps quite a convoluted way of putting what was intended to be a simple point. I can put it more shortly. A decision to remove someone to a person, to a territory where they can't lawfully be removed isn't in accordance with the law. That's
lawful under which system of law?
Under the Immigration Acts, Schedule 2, or under general...
Well, is there anything in
public
English law which says that it's unlawful to send people to Palestine?
Well, there's nothing that specifically relates to Palestine, but when one looks at the removal provisions in paragraphs 8 to 10 of the 1971 Act, there are set out there a list of the types of countries or territories to which removal is possible. And on the facts of this particular case, Palestine doesn't fall within that list, as it were.
Well, that's a question of fact, isn't it? Because one of the types of places, not just a country or territory where he has a passport or document of identity, but a country or territory to which there's reason to believe that he'd be omitted.
Yes.
So there's nothing inherently unlawful about Palestine. It's a question of fact, is it? Whether there's reason to believe he'd be admitted.
Yes. If one looks at the list in paragraph 8.1c, and that's behind tab 1 of volume 1, and it's page 39. 4 countries are defined, countries or territories, a country of which he is a national or citizen, or a country or territory in which he's obtained a passport or other document of identity, a country or territory in which he embarked for the UK, or a country or territory to which there's reason to believe that he will be admitted. The first three countries or territories would seem to raise very straightforward questions of fact, which, in my submission, are entirely suited for determination by a tribunal which has factual competence, such as the first-tier asylum and immigration tribunal, and which are not at all suitable for determination by the administrative court, which doesn't have, ordinarily at least, factual competence, and which is really set up to deal with, if I may say so, much more complicated questions. The fourth category of country or territory raises potentially slightly more tricky issues, country or territory to which there's reason to believe that he will be admitted. Depending on the facts of the case, that may raise questions of law and policy, in particular foreign law and policy, as well, of course, as a number of different types of factual issues. And again, those are all the sorts of issues that a specialist tribunal with jurisdiction over the facts is eminently suited to consider and determine, along with the other issues.
But that doesn't answer the question of construction.
There
are many questions that have to go to the administrative court because there's nowhere else for them to go, which are not necessarily well suited to the administrative court as it's currently set up.
No, absolutely. That doesn't answer the question of construction at all. As far as the question of, that doesn't comprehensively answer the question of construction, but it may be relevant to the question of construction for reasons I'll endeavour to develop very shortly. On the construction point, I intend to be making essentially four fairly short and straightforward submissions. And I'll set them out in brief now and develop them later, if I may. The first submission that we make is that the decision in 82.2h refers to a decision that's required to be made under paras 8 to 10 of Schedule 2 to the 1971 Act. And if one looks at Schedule 2 to the 1971 Act, it is clear that the decision required to be made is a straightforward decision simply to give removal directions and to give those removal directions to a particular country or territory. So if one looks at the 1971 Act to answer the point of construction point, one sees that the nature of the immigration decision is one that includes the identification of a country or territory of removal which is within the paragraph 8.1c list and therefore is lawful in that sense.
Is that necessarily right? I mean, I don't know whether it's appropriate to take it now or when you come back to it, but actually, under paragraph 8.1a and b, you can have removal directions which don't specify the country to which a person is to be removed, and C is an alternative. Actually, A and B are alternatives. They're three. There's an or at the end of each. So the only requirement to specify the country to which you're to be, absolute requirement under H to specify the country to which you're to be removed derives from the regulations.
Well, certainly the regulations are our next point, but 8.1c, to which one comes back to when one makes removal directions as the immigration officer or the Secretary of State under paragraphs 9 and 10, requires that directions...
Well, I see that, but
Yes.
8.1c is actually something which doesn't have to be activated.
No.
In theory, you could just give the captain of the ship on which someone arrived under A directions to take him away.
Oh, sorry, 8.1a.
Well, yes, that's my
Oh, no,
point.
that's-
Under 8.1a or b. But you were saying a moment ago
Yes.
that the scheme of regulations 8, paragraphs 8 to 10 of Schedule 2 referred to in the section 82.2h was inevitably to require a country to which someone's to be removed to be specified. That's not so under the statutory scheme. It may become so when you actually add in the regulations. I mean, you
Yes,
could, in other words, have different regulations. You
I-
could alter the regulations and not have an absolute requirement in every case under H, falling within H, to have a country of destination.
I stand corrected. I put it slightly too broadly, if I can reformulate that first point. If the decision required to be made under Section 82.2h is a decision under Schedule 2, and if one looks at Schedule 2, it's clear that the decision is a straightforward decision simply to give removal directions,
Yes.
and to give those removal directions in a way that's authorised under paragraphs 8 to 10. Now, in some cases, what is authorised is simply the giving of removal directions to the captain of a ship or aircraft in which the person arrived, as your Lordship has just pointed out, under 8.1a. In this particular case, it's been common ground, for reasons I'll explain very shortly. The only removal directions that could be given in this particular case are within 8.1c, and on the facts of this particular case, that would therefore require the specification of a country or territory. But the second point that we make does very much, as my Lord Muntz has indicated, turn on the notices regulations. And what we say about the notices regulations very simply is that they ensure that the country or territory of proposed removal is formally part of the immigration decision and appealable as such. That's the second point to be developed. Then our third point shifts the focus from 82.2h onto section 84. And what we say is that no matter how narrowly one construes the 82.2h decision, the ground of appeal in 84.1e is broad enough to found an appeal on the basis that the Secretary of State's underlying view about the country of destination is inconsistent with the Immigration Acts or public law. And then I propose to make some submissions that may not sit that easily with an observation just made by my Lady Baroness Hale, but I'm proposing to go on to submit that there are strong policy reasons embodied in the legislation why any dispute about the lawfulness of a proposed removal to a particular country actually should be resolved as part of the appeal and not by virtue of any later judicial review of the giving of removal directions. But I'll see how far I get on the public policy point when I come to it. We then make a fourth, related to that, we make a fourth type of submission, that if one looks at the one-stop provisions in section 120 of the 2002 Act and similar provisions directed at streamlining the process and making it speedier and cheaper, that calls for a broad construction of sections 82 and 84. And I don't really propose as a fifth point to deal with the legislative history in any great detail. I intend to look at it very briefly and just to indicate there's nothing in it that's inconsistent with our approach, and one has to really, at the end of the day, look at the provisions in the 2002 Act and try to work out where Parliament has drawn the dividing line between the decision-making process, which is subject to an appeal, and the sort of machinery of giving removal directions, which is common ground, is not subject to an appeal, and at best would be subject to a judicial review later on. If I start the paper chase back at section 82.2h, the decision is a decision that an illegal entrant is to be removed from the UK by way of directions under Paras 8 to 10 of Schedule 2 to the 1971 Act. If one looks at section 82, which is behind tab 8, and it's page 12, one key feature of section 82 is that none of the immigration decisions are decisions refusing a claim for asylum under the Refugee Convention or refusing an application for protection under the Human Rights Convention. And I'll come back to the significance of that later on when looking at the notices regulations. Another feature of section 82 is, in general, is that it tells one what decisions are appealable, but it doesn't itself provide a statutory basis for the making of any of these decisions. The decision under section 82A, refusal of leave to enter the UK, that's a decision made, for example, under the 1971 Act, and the decision under section 82H manifestly is a decision that's made under the 1971 Act. So my point is that in order to understand exactly what type of decision section 82H is driving at, one needs to look at the 1971 Act. And there are specific reasons why that must be the case. The decision under 82.2h is a decision expressly that the person from abroad is to be removed under the specific provisions referred to, that is, under Paras 8 to 10 of Schedule 2, i.e., on the basis that those provisions apply in law and in fact. And second, if one looks at the range of decisions described in Section 82, one sees that between Section 82G and Section 82(1)A, there are 5 decisions, all connected with removing persons.
Isn't it IA, not 1A?
IA, sorry, it is IA.
Oh, good.
But there are 5 of them, sure about that.
And
there
does
are
your
5.
argument apply to each of them?
Yes, it would. Although the point I was just about to make is that there are 5 different types of immigration decision, all relating to the different types of ways in which people can be removed from the UK. So if one compares and contrasts the language used in G, H, HA, I, and IA, that suggests that in a Section 82H case, there has to be a focus on whether the person is an illegal entrant, because that's a new feature that isn't in any of the other categories. But second, there should be a focus on whether or not it would be lawful to remove the person concerned, specifically under paragraphs 8 to 10, as opposed to any of the other removal provisions. Otherwise, it's hard to see why the draftsman took such care to compare and contrast the different removal avenues, and why he didn't simply describe the decision, the immigration decision, as a decision in principle that a person ought to be removed from the UK, as the Secretary of State puts it. And that's why, yes, my submission would apply in all of the different, to all of the different sub-paragraphs, that one is inevitably directed to look at the specific removals machinery identified under the specific sub-paragraph. And the importance, my third point, is that the importance of maintaining a focus on whether removal can be effected under the specific machinery in each subsection. That's underlined by Section 86(3). That's still behind tab 8, obviously, and Section 86 starts on page 19. Subsection 1, this section applies on an appeal under Section 82(1), among others. In subsection 3, it is provided that the tribunal must allow the appeal insofar as it thinks that a decision against which the appeal is brought or is treated as being brought wasn't in accordance with the law, including the immigration rules. And then at subsection 4, it's provided that for the purposes of subsection 3, a decision that a person should be removed from the United Kingdom under a provision shall not be regarded as unlawful if it could have been lawfully made by reference to removal under another provision. So exactly which removal procedure can be used is immaterial, ultimately, to the lawfulness of the decision. But it is essential that a viable removal procedure under a specific removal process is identified, and 86(4) does ultimately require the Secretary of State, in my respectful submission, to justify the lawfulness of a decision to be removed by reference to at least one specific type of removals machinery. And before going to the provisions of the 1971 Act, may I submit at once that we respectfully take issue with the approach of the Secretary of State in paragraph 2 of his written case, where he submits that a decision to remove is really a two-stage or twofold decision. He says that, first of all, the statutory scheme requires there to be a decision in principle that a person is to be removed from the UK, and then a decision to actually give removal directions. And that could be weeks, months, or years later. And in MS's case, as the Secretary of State indicates, that second part of the decision to remove hasn't yet been made, with the consequence on the Secretary of State's case that MS simply can't appeal the decision on the face of it that is to be removed to a particular country. What we say is if you look at the 1971 Act, it's all a lot simpler, and that what is required is simply a decision to give removal directions from the UK and to another country. And that is the decision that's referred to in section 82(2)H. So if one turns to tab 1, sections 1 to 3 of the 1971 Act deal with the general principles of immigration control. Now, I imagine that the members of this court will have seen these provisions time and time again, and I don't propose to add to the pleasure that may already have been derived from that process, but to go, unless invited to do so, of course, but to go to section 4.
Sorry, which tab are you in at the moment?
This is tab 1.
Tab 1.
Sections 1 to 3 give the general structure of immigration control. Section 4, which is page 14, gives effect to Schedule 2 and probably tells one as much as one needs to know about the general structure of immigration control for the purposes of this appeal. Under 4.1, the power under this Act to give or refuse leave to enter the UK shall be exercised by immigration officers, and the power to give leave to remain in the UK or to vary any leave under section 3.3a shall be exercised by the Secretary of State, and, unless otherwise allowed by or under this Act, those powers should be exercised by notice in writing given to the person affected. Then Schedule 2 is given effect to with respect to A, the appointment and powers of immigration officers who will be giving or refusing leave to enter the UK. B, the examination of persons arriving in or leaving the UK by ship or aircraft. C, the exercise by immigration officers of their powers in relation to entry in the UK and the removal from the UK of persons refused leave to enter or entering or remaining unlawfully. And then D, the detention of persons pending examination or pending removal from the UK, and then other supplementary purposes. So again, I just make 2 points about this. First, the general structure of immigration control turns on grants or refusals of leave to enter or leave to remain on the one hand, and removal directions on the other hand. It doesn't embrace the determination of refugee convention applications or human rights convention applications. That's done by the Secretary of State under the immigration rules in the case of refugee convention applications and under his policies in the case of different types of human rights, in the case of human rights convention applications. And just for your lordships and my lady's note, there's in the Anifrieva case, which is in volume 3, tab 24, paragraphs 2 to 8 of Lord Bingham's dissenting judgment gives a summary of how basic immigration control works and of the relationship between refugee convention decisions by the Secretary of State and decisions refusing leave to enter or remain, decisions refusing leave to enter by the immigration officer. Essentially, the file goes, after an examination by the immigration officer, the file goes to the Secretary of State. He, for example, rejects the refugee convention application and then, in the ordinary case, sends the file back to the immigration officer, who then reconsiders the case and decides whether or not to grant leave to enter. In fact, since Anifrieva, the statutory framework has changed slightly in that the Secretary of State now has power to himself decide whether or not to grant leave to enter when he's considered an asylum claim. But Lord Bingham's speech gives a good summary of how immigration control essentially works. The other point about Section 4 is that one can't find in Section 4 or in Sections 1 to 3 any reference to the word decision, let alone any express requirement in the statute that the immigration officer or the Secretary of State actually has to make a decision. All one sees in Section 4 is that there's a narrative thread running through Sections 4 to A to D that does require decisions to be made. Once the immigration officers are appointed under 4.2a, they are implicitly required to decide under 4.2b whether and to what extent to examine somebody, under 4.2c whether to refuse entry, under 4.2c whether to remove, and then under 4.2d whether to detain pending examination and removal. And one sees this constantly in the 1971 Act, that it's just implicit that the decisions are going to have to be made before actions are taken. And if one goes to Schedule 2, one comes much closer to the issues that arise directly in this case. Just to follow the structure of Section 4 in Schedule 2, which starts at page 34 of 71. Right at the bottom, first of all, as presaged by Section 4.2a, there's provision for immigration officers to be appointed. One doesn't need to look at the detail of that. And then at paragraph 2, there's provision for immigration officers to examine people who arrive in the UK. There's no need for more detail about that. Paragraph 6, page 38, there is provision for the immigration officer to give leave to enter or refuse leave to enter. And one doesn't need to look at that in any more detail. And then one gets to paragraphs 8 to 10, which are the critical provisions. I'll look at them in a little bit more detail, though I imagine your Lordships and my Lady will have already spent some time looking at these. Paragraph 8, where a person arriving in the UK is refused leave to enter, an immigration officer, not the Secretary of State, may, subject to subparagraph 2 below, A, give the captain of the ship or aircraft in which he arrives directions requiring the captain to remove him from the UK in that ship or aircraft. And that is just removal from, of course, to use the language of the Secretary of State, although it may be implicit that the ship or aircraft is likely to go back whence it came. B, give the owners or agents of that ship or aircraft directions requiring them to move in from the UK in any ship or aircraft. So again, that's a removal from the UK, and I suppose it clearly needn't be to the place from where the person arrived. And then C, give those owners or agents directions requiring them to make arrangements for his removal from the UK in any ship or aircraft specified or indicated in the direction. And here one at last gets a to a country or territory, so specified, being either A, a country of which he's a national or citizen, B, a country or territory in which he's obtained a passport or other document of identity, 3, country or territory in which he embarked, or 4, country or territory in which there's a reason to believe he'll be admitted. If I may, I'm going to come back to 8.1c, but just to give the court the basic sort of narrative and structure of it. You'll see from 8.2 that directions can't be given under 8.1 after, in certain circumstances, after a period of time. Paragraph 9, where an illegal entrant is not given leave to enter or remain in the UK, an immigration officer, again, not the Secretary of State, may give any such directions in respect of him as in a case within paragraph 8 above or authorised by paragraph 8.1. So that's the whole gamut of those removal directions.
So basically, if the restrictions in paragraph 8.1c only apply where the people who brought him here are being required to make arrangements in a different ship or aircraft from one that's under their control.
I think that's right. 8.1a is a direction that relates to the very ship or aircraft in which the person has arrived.
That's the actual one. B is the same owners or agents in anything that they have. C
absolutely
also seems to be the same owner or agent. which
Yes.
is very odd. What about a person who has stowed away in some vehicle you know not what?
Well,
How do you get rid of them?
That's 12. Sorry, isn't
or
it?
10.
Sorry, that's...
That's 10.
That's
10.
somewhere else, isn't it?
Yes. That's 10. And I can preface it by just making a very short submission about paragraph. No, we can go straight on to paragraph 10. Where it appears to the Secretary of State, and this is the Secretary of State now rather than the immigration officer, either A, that directions might be given in respect to the person under paragraph 8 or 9 above, but that it is not practicable for them to be given, or that if given they would be ineffective, or B, that directions might have been given in respect to the person under para 8 above, but the requirements of para 8.2 haven't been complied with, so time has gone past without a special notice having been given. Then the Secretary of State may give to the owners or agents of any ship or aircraft any such directions in respect of that person as are authorised by paragraph 8.1c. And then there's a further power in what one might call difficult cases under 10.2, where the Secretary of State may give directions for a person's removal in accordance with subpara 1 above. He may instead give directions for his removal in accordance with arrangements to be made by the Secretary of State to any country or territory to which he could be removed under subparagraph 1. And that paragraph 10.2 doesn't require directions to be given to any owners or agents of any ship or aircraft, let alone the ones in which the person might have arrived. So if one, to answer my Lady Baroness Hale's query, paragraph 10.1a will apply inter alia when the Secretary of State doesn't know who the carrier is, i.e. or e.g. in which ship or aircraft the person from abroad arrived.
How would it work in this case where it is known?
Well, I'm not sure that it is known.
Well,
my Lord.
the lorry driver called the police, didn't he? So,
Yeah.
So the identity, and also, would it be the lorry or Eurotunnel, which is the relevant?
Well, it could. Well, the lorry could have arrived in the UK via the Eurotunnel or via a ship.
Well, all this is known.
I'm not sure that it is known by the Secretary of State. I stand to be corrected if I'm wrong, but sort of addressing the point in principle, there will be cases where the Secretary of State will not know in which ship or aircraft a person arrived.
Oh, yes, well, this is neither a Eurotunnel nor a lorry,
for example.
Ship or aircraft.
Yeah. And then if he doesn't know who the carrier is, or if for some other reason it's not practicable or effective to give directions to that carrier, then the Secretary of State can make removal directions himself, and they have to be, they are limited to the directions that are authorised by paragraph 8.1c, and that's the basis on which this particular case has proceeded. Not that it would make any significant difference to my argument.
It has to, because obviously the lorry can't be, or the Eurotunnel can't be asked to return him to Egypt or to the West Bank.
Well, that would be a very good example, if I may say so, of a case where the Secretary of State would know of the identity of the carrier, for example, but it just wouldn't be practical. And I say that even though paragraphs 8 to 10 are focusing on ships or aircraft, and your Lordship has raised the question of the tunnel. There is a Channel Tunnel order, and we spent some time looking at it and decided not to prolong the agony by actually positively bringing it to court. And we don't have it here, but we could find it if you wanted. But it essentially makes a very similar sort of provision to paragraphs 8 to 10 for Channel Tunnel cases. There are all sorts of different ways in which a person might arrive, which might pose conceptual difficulties. Shoehorning them into paragraphs 8 to 10, I'm not aware of any case where anyone seriously suggested the Secretary of State doesn't ultimately have a power to remove, irrespective of how someone's got in.
Well, it's obviously contemplated that the the person could be sent back to the country from which they came.
Oh, absolutely.
So France in this particular case, presumably.
Yes, if France was specified in the removal directions, that would, on the facts of this particular case, satisfy 8C little 3. And then that would be it as far as concerns in accordance with the law, unless on the facts of a particular case there was in addition some irrationality argument or some other legal argument which indicated that in fact a return to France would be impossible. But it would certainly be it as far as concerns the simple argument of simply arguing that the country isn't on the paragraph 8C list.
I'm not quite sure whether it's been covered by the discussion a moment ago, but I don't think it has. What is the position if you're not sure whether somebody's arrived by ship or aircraft or by Eurotunnel, either by train or by lorry?
Yes, they might have swum.
In order to operate 10, you have to be satisfied that directions might be given in respect of a person under 8 or 9. So it only applies where you can say, I'm sure you came in by ship or aircraft.
Yes. Well, yeah,
Sounds as
We've
if
had
we do need the Channel Tunnel order, don't we?
well, the Channel Tunnel order would answer the question if one knew.
Because if it's in the same terms, you have to show you came in by Channel Tunnel.
Absolutely, it would answer the question if one knew that the person had come in from the Channel Tunnel. But Mr. Seddon and I have had quite a lot of fun, not in recent days, but a little bit earlier, trying to work out what would happen if it was fairly clear that someone had just swum here or, paddled their own canoe here, and how would that fit in paragraphs 8 to 10? And it wouldn't fit in very easily, and obviously it wouldn't, as my Lord Mance has indicated, it wouldn't really fit in with the Channel Tunnel order either. I think the Secretary of State's policy approach is that in that sort of case, it generally appears to him that directions might be given under paragraphs 8 or 9 above, and then he proceeds to give them. We're not aware of any case where that's been challenged. But
I mean, it may be that the cases which fall within Section 82 are in practice going to be cases where you do know how someone's arrived. Is that right? I mean, refusal of entry clearance, obviously you presumably know how they're trying to enter. Refusal of leave to enter, likewise. Maybe the other ones are similar.
Well, they're broader than that, my Lord, because...
Yes, obviously they're broader, but I mean, are they all cases where in practice there'd be some way of knowing how the person had got here? Perhaps not.
Well, I mean, if one looks at paragraph 8.1c, I think that probably raises two different sorts of issues. By and large, as a matter of practice, the Secretary of State, imagine, is able to work out how somebody has got here and fit that case somehow within paragraphs 8 to 10. But if one looks at paragraph 8.1c, the power to make directions doesn't turn on whether the Secretary of State actually knows. Well, if one looks at the selection of countries or territories in 8.1c, that doesn't turn on the Secretary of State knowing how exactly somebody got here. It would be enough to know that the person concerned was a national of a particular country or had a passport. One wouldn't...
Well, except it starts off, give those agents names
well,
agents as
no, absolutely. Then there's that fundamental problem that everything in paragraphs 8 to 10 is sort of pinned back to the Secretary of State, at least to it appearing to the Secretary of State that he might be able to give directions under paras 8 or 9, and that does, as your Lordship rightly says, turn on the Secretary of State believing that there are owners or agents of a ship or aircraft, or that the Channel Tunnel order applies, or that it came in through the Channel Tunnel. So, but what we can't really. We're not here in the business of standing up and submitting. The Secretary of State has no power to remove anybody who swims to the UK or paddles a canoe here. But on the face of it, there's a sort of potentially entertaining difficulty under the removal directions. But I'm not positively submitting that it can't be done, because that would seem strange. But we don't actually know. We haven't worked out how the Secretary of State could get around that problem in a logical, watertight way. But he does it in practice, I understand, from Mr. Seddon and those sitting behind me, by deciding that it appears to him that that is the case, and maybe doing him a disservice.
In fact, it's not entirely clear how he did arrive in this case. I'm just looking at the appendix, page 44. It just says, you arrived in the UK in a lorry on the 25th of April 2007, and after banging the side of the lorry, the driver stopped and rang the police. So he could have come by ferry or through Eurotunnel.
Yes, he could have done.
So we don't actually know if we're dealing with the right provisions at all.
Well, our understanding has been that because the Secretary of State hasn't known precisely how MS is
he thinks he can apply these provisions.
Well, then he certainly can in this particular case, because if one arrives in a lorry, one definitely will have arrived via a ship or a train through the Channel Tunnel. I mean, I take the point that it could be Paris 810 or it could be the Channel Tunnel order, but the effect, when we can bring the Channel Tunnel order, the effect would be exactly the same. He'd be exercising his power under paragraph 10, or the equivalent power in the Channel Tunnel order, to make the sort of directions that can be made under 81C. And so, by whatever route, one gets back to 81C, and that's why the focus has been exclusively on 81C. From both sides.
So the Channel Tunnel order does apply 81C, does it?
It would produce exactly the same result.
Well, I know, but is it? I mean, H only deals with paragraphs 8 to 10 of Schedule 2. That's the point. So, which only deals with ships or aircraft.
Yeah. What I can do is, and I could try to make a submission about that now, but it might be possibly more helpful if I was to sit down and revive our Channel Tunnel order, possibly with the assistance maybe of Mr. Eichel or Mr. John Paul Waite at lunchtime, and then just concisely give the court an exact summary of the position under the Channel Tunnel. But as presently advised, my understanding is that it would come back to exactly the criteria that one finds in 81C in a case where the Secretary of State wasn't sure whether it was ship or lorry. And there'll be no underlying bizarre jurisdictional question about whether removal directions could actually be made in one shape or form, because it would be ship or train. I'm sorry not to have really brought the Channel Tunnel order along. We thought there was no point, since it's proceeded on the basis that it's a paragraph 81C case, and that's in the Statement of Facts and Issues. But we may have made the wrong judgment there, so we'll bring that along and make sure the court has it. So paragraph 8, of course, couldn't apply to MS, because he, as the court's seen, arrived clandestinely in a lorry, and he didn't get out of the lorry until it had passed through immigration control. So he does not fall within the category of people, of a person arriving in the UK who's refused leave to enter, because he already entered. So he's somebody asking for leave to remain. So just returning then to, on the sort of hypothesis that 8.1c is the material provision for the purposes of this case.
Is that actually right that he's asking for leave to remain? Hasn't he first got to have leave to be here, which he hasn't got?
Well,
So that's a technicality that probably is irrelevant to the point and issue, so please don't pursue it.
my understanding, my lady, is that once somebody has entered the UK unlawfully or illegally, because they've entered, they can't be granted leave to enter since they have already entered, and therefore their stay is regularised by the grant of leave to remain. That is right. I'm reliably informed. Of course, it's different in cases, and your ladyship may be thinking of these cases, in cases where a person reveals themselves at the port before they pass through immigration control. They are then granted temporary admission under paragraph 21 of Schedule 2, and by virtue of Section 11 of the 1971 Act, those people are deemed not to have entered the UK so long as they remain on temporary admission, and so they are always in the position of applying for leave to enter rather than leave to remain. But somebody who circumvents and bypasses immigration control has already entered and therefore applies for and gets only leave to remain, and therefore is dealing with the Secretary of State. There is I want to get back to paragraph 8.1c, but Mr. Seddon's pointed out that members of the court may be puzzled by my explanation when they read paragraph 9 of Schedule 2, which refers to an illegal entrant who is not given leave to enter or remain in the UK. And how does that tally with the explanation I've given? Well, I think Einstein once said that the incomprehensible thing about the universe is that it is comprehensible. And the almost incomprehensible thing about the Immigration Acts is that they are often comprehensible. And the answer to this is that a legal entrant is given a special definition by Section 33 of the Act as somebody who has entered or is attempting to enter unlawfully. So,
I'm sorry, where is that definition?
Section 33, I think it would be right at the very end.
Section 33.
Paragraph 33.
Paragraph 33.
Section. It is Section 33, isn't it? It is Section 33. At page 65. It starts at page 65. Sorry.
It must be paragraph.
Sorry, no, it's not page. Page 31.
That's more like it.
Towards the bottom of that page, entrant means a person entering or seeking to enter the UK, and illegal entrant means a person unlawfully entering or seeking to enter in breach of a deportation order or of the immigration laws, or entering or seeking to enter by means which include deception by another person. So, although somebody who has entered the UK in the sense of completely bypassing immigration control has entered and can only get leave to remain, an illegal entrant can be somebody who remains a person who's seeking leave to enter, because the definition of illegal entrant includes somebody who hasn't actually entered the UK. That's how it works. And bizarre thing about this part of the immigration universe is that it is just about comprehensible when one reads it through. But returning, if I may, to paragraph 81C, because these are the legal provisions for the purposes of this appeal. You have 4 different categories of country or territory. 1 to 3, obviously very straightforward questions of fact, entirely suitable for a tribunal with factual competence to decide. Not very suitable for the administrative court to determine, because the administrative court doesn't have jurisdiction ordinarily over factual issues, and frankly is suited to determining more complex and weighty matters. Paragraph 4 is of particular interest in this particular case. Country or territory to which there is reason to believe that he will be admitted, and I'll spend maybe a little bit of time on Roman numeral 4. Admitted means, in my submission, where he will be allowed in, probably to reside, by whoever is in legal control of the border, or in very unusual cases, like Somalia, for example, in de facto control of the border. So one isn't concerned with whether there's a safe route of return from the UK to the border. One isn't concerned whether there's a safe route from the border to the person's home area, but whether he will be admitted across the border. And what we say about that is, I hope, consistent with the point put to me by Lord Mance earlier on, that that ultimately is a pretty straightforward question, whether in all the circumstances there's reason to believe that the person will be admitted. But the range of circumstances won't necessarily be completely narrow. There might be no reason to believe that the person will be admitted, for example, because the country won't let him in for legal reasons or reasons of policy or principle. It may be possible on the evidence to discern that there is a sort of fundamental legal or principled or policy objection on the part of that foreign state, so that one knows that this sort of person is just not going to be allowed to cross the border. Or there might be no reason to believe that someone will be admitted because there is no realistic possibility that he has or will be able to get the necessary documentation. And here one gets a little bit closer to some of the issues in this case.
I'm not sure I follow why we're going into all of this. Is it leading up to the submission that the sort of questions that are raised by little 4 are ones which Parliament could not have intended should be resolved in the event of dispute by judicial review? Is that the submission?
I think that's one of the submissions that I'll ultimately make. At the moment, I'm just trying to sort of go through and make sense of paragraphs 8 to 10.
No, but you seem to be making up something of the complexity of these, the difficulty of these kind of questions. And it seems to me that can only be because this is leading up to a submission that the construction which was placed upon this by the Court of Appeal cannot have been intended by Parliament, because it could not have been intended that this sort of question should be resolved in the event of dispute by judicial review.
But I will make that submission, although that's not my strongest submission, I think, on paragraphs 8 to 10. Leaving aside the detail at your Lordship's invitation, my main point about paragraphs 8 to 10 is that it's implicit in these paragraphs that the immigration officer under paragraphs 8 and 9 and the Secretary of State under paragraph 10 has to make a decision before he gives removal directions. There's no reference to a decision in here, but it's implicit in paragraphs 8 to 10 that a decision has to be made. And one knows it's implicit that a decision has to be made because every formulation of the power to give removal directions makes it quite clear that it's a power, and that the immigration officer or the Secretary of State quote, may, unquote, give removal directions. So I say it's implicit that a decision has to be made.
Well, the decision is obvious. It's the making of the directions. You can't make directions without making a decision that you're going to make the directions. But that's at a later stage. And at that later stage, the question is whether there's reason to believe that he'll be admitted. You don't actually decide whether he will be admitted, but whether there's reason to believe. Now, at the earlier stage, we're considering, when you're dealing with the immigration decision, to be removed, then the only decision required then is that he's to be removed by way of future directions under Schedule 2. So at that stage, presumably the question is, does the immigration, whoever makes the immigration decision, have reasonable grounds for thinking that at some future date he may have reason to believe that there is a country or territory to which this person may be admitted and in respect of whom therefore directions may be given. So it's a double question, isn't it?
It's a double question. And,
so you're pretty far away from the question whether he will actually be admitted.
Absolutely. It's a double question. Can I take it in two parts? The first, the sort of threshold of belief that's required under Roman numeral 4. It's absolutely right that the hurdle for the Secretary of State to cross in his own mind under paragraph 10, and the hurdle for the Secretary of State to cross, if we're right, on an appeal, is quite low. He simply has to have reason to believe that is now, obviously, have reason to believe now, that the person concerned will be admitted to the country, and that is clearly in the future. So there's nothing in paragraph 8(1)(c)(4) that requires the Secretary of State to have in his hand, when he makes the decision, or even before the tribunal, if we're right about jurisdiction, there's nothing that requires the Secretary of State to have in his hand travel documents or any of the relevant paperwork. Nor is it required that the Secretary of State would be able to establish that he can get hold of all the necessary paperwork very speedily, or the next day or anything like that. So it is a very low threshold, and to succeed, but it's a low threshold, but it's not a threshold that no person from abroad will ever cross, far from it. It's just that to succeed, the person from abroad would have to establish the existence of a pretty fundamental problem, such as to mean that there was no reason to believe he would be admitted. So he would have to point to a difficulty of principle, a fundamental legal or policy impediment raised by the foreign country, which meant that as an individual, there was just no reason to believe that he would ever be allowed to cross the border because of who he was or the category he fell into. Or he would have to show a sort of fundamental problem in getting hold of the relevant paperwork, such that there was simply no reason to believe, very extreme case, such that there was no reason to believe that the relevant paperwork could be got hold of within...
Would ever, I mean, that he could never show that was impossible for all time.
No,
how do you put it? You say within a reasonable time. I think that's what you do say, isn't it?
I'm not... If I said ever, I didn't mean to.
You did say ever, but I think you meant within a reasonable time.
I meant within a reasonable time. I'm very grateful that that's exactly what I meant. And there's a reason for that, which is that if we're right about jurisdiction, when the tribunal considers this issue, it will have to decide what is a reasonable time in the light of all the circumstances of the case. That is, the difficulties, obviously, that confront the Secretary of State, that the tribunal will naturally be highly sympathetic to, but also the circumstances of the person from abroad. Those circumstances might tell against the person from abroad, but they also might raise issues in his favour.
That may not be entirely realistic. The legislation and the decision both proceed on the basis that if the immigrant is refused leave to remain, he or she may leave voluntarily. That's
Yes.
what the decision itself says.
And that
For example, in this case, he may have relatives in the United States. He may be entitled to apply to go there, for example.
yes. Well, that would, if your lordship is putting to me that the possibility of a voluntary return, if there was evidence about that, would be relevant to the assessment of what is a reasonable period, then I would respectfully accept that.
No, I think my question really goes to the difference between the decisions.
Presumably some people may leave voluntarily, may they? I mean, because conditions are so unpleasant if you haven't got leave to remain.
And also it gives choices as to how, when, where. And in some situations, being returned compulsorily is obviously rather more obvious to the people, to the place where you're going, and may bring with it unwelcome consequences, all sorts of reasons why somebody might.
Yes.
Actually, once having been told, look, end of the road,
Yes.
go of their own accord.
Lady, I think I know what my response is, but I'll just check with Mr. Check something very briefly. Yeah. Yes. In a direct response to the question posed by Lord Collins, the country there has to be reason to believe that the person from abroad will be admitted to the particular country or territory, either by virtue of the enforced removal, or as it's been put to me, if he returns there on a voluntary basis. That would be sufficient.
But if he returns on a voluntary basis, paragraphs 8 to 10 have got nothing to do with the case at all, haven't they?
Yes, that would. Yes. It doesn't directly engage your lordship's point, but the basis of the immigration decision is that it's a decision that if you don't leave voluntarily, directions will be given for your removal from the UK to the Palestinian.
That's what the notice. That's what the notice told your client, that he must go away at once, and if he doesn't, he will be forcibly removed.
Well, there's two ways of construing paragraph 81C4. One is that one has to believe that the designated country is a place where the person from abroad will be admitted in the course of an enforced removal under this scheme. That would be the narrow approach, or that it's a country or territory to which there is a reason to believe that he will be admitted including if he makes his own way there voluntarily, and that's the broader approach to 81C4 that I thought was being
I'm sorry, I'm being
suggested.
very slow, but he is told that his claim for asylum or human rights have been rejected, that he's an illegal entrant, and that if he doesn't leave voluntarily, directions will be given for his removal from the United Kingdom. And what we're looking at, surely, paragraphs 8 to 10, is the case where he's chosen not to leave voluntarily. And he can go wherever he likes, provided he can find someone to take him.
So in fact, the narrow approach must be right, that it's a country or territory to which there's reason to believe that he will be admitted on an enforced removal.
On an enforced removal,
enforced
yes.
removal.
The effect of the notice regulations is that in the original decision, the applicant is told, if you do not leave voluntarily, either to the country to which we're proposing to remove you, or to any other country, we will remove you to that country.
Yes, absolutely, I accept that. I think I'm halfway through answering a question of Lord Manse's, which was a sort of double-barrelled question. Part of it was the scope of 81C little 4, and the extent to which it embraced various different sorts of practical difficulties, and the fact that the threshold here is very, very low.
Yes.
And just to finish that point, had he been allowed to appeal MS's case, what wasn't put on the basis that as a matter of principle he fell within a category of people who just would not be allowed across the border. It was put on the basis of practicality, on the basis of evidence from the Palestine General Delegate's office, that it was, quote, impossible, unquote, for him to get the necessary documentation, and his case was put that on that basis there was no reason to believe that he would be admitted to the West Bank or Gaza.
Yes, you put it
For
as
the
high as
foreseeable
you can, but I mean, on your case, there is this two-stage approach on any view, and the Secretary of State might get over the first hurdle, but nonetheless, when it actually came to the point at which directions for removal were given, your client, either because of changed circumstances or because of better evidence, might be able to say, well, whatever was the position earlier, with the validity of the immigration decision, any removal directions will be unlawful, and I'll challenge them, if necessary, by judicial review. I think that's the only route at that stage. So we don't get over the problem that everything isn't resolved, because the situation will be different and the tests are actually slightly different.
It's a fair point that issues might arise in the future that, because of changed circumstances, couldn't have been canvassed in an appeal against the original immigration decision. But take this case. MS's point, rightly or wrongly, and it wasn't explored in evidence or
Is
argument,
it simply impossible?
is that it's simply impossible, and therefore, as at the date of the decision, there simply was no reason to believe that he would be admitted. And his simple point is, well, this decision's been made about me, and I'm being told I can't appeal it for months or years.
What's happened up until now? I mean, we're told that the Secretary of State has applied his present policy, I mean, presumably the position is that if one had a situation where actually removal was impossible, then the Secretary of State would give him make his immigration decision, but he would then rapidly realise when he came to try to, or the immigration officer came to try to give removal directions, that that couldn't be done. And so the person would stay here in practice, presumably. I mean, is there any evidence of people being taken to the borders of foreign countries and then finding that they can't get in? I assume that what happens in practice is that no removal directions are given.
Well, there are a few cases, which are reported cases, where somebody has been taken to a border, returned back, and then there have been further removal directions, and they've been subject to judicial review, perhaps unsurprisingly in the circumstances. So there's been a few cases like that, but one would assume that would not happen very often. I think our case makes.
So what more protection? I mean, in a sense, do you need? What's the importance of challenging it at the early stage?
Well, I think our case makes it fairly transparent why we're taking the points we are on behalf of MS. He would prefer the issue of his returnability to one country or another to be resolved at an early stage for two reasons. One, because he can be clearer about where he stands if he's going to be removed. If he can be removed to a particular country, he would like to know that as soon as possible. And secondly, because if, as he suspects, it is actually impossible for him to be removed to Palestine in any foreseeable scenario. That may be right, that may be wrong, it's not been tested. But if that is right, then, and I put it no higher than this for the purpose of this appeal, that circumstance would, depending on a lot of other circumstances, tilt in his favour when the Secretary of State then had to consider what action to take in respect of him, namely whether to continue to maintain him on temporary admission or to grant him some form of limited leave to remain. And that decision,
or send him back to France?
well, or send him back to France. At least he'd know, and he'd be sent back to France. If the Secretary of State wants to send him back to France, let him say so, and let that be, dealt with at the same time as the rest of the immigration appeal. Why people don't like temporary admission, Lord, is that it places one in something of a limbo position. In almost every case, when one's on temporary admission, one is prohibited from employment. Obviously, one's prohibited from mainstream benefits. One is subject to reporting restrictions and that sort of thing. But the big point is that one can't take employment and sort of participate in ordinary life. So if you have a very, very weak immigration claim and just want to string things out, then for you, temporary admission, maybe that's a good state of affairs. But if you think you have a strong case and in any event don't want things to be strung out, then like MS, you would want things to be brought to a head so that either you're going to be removed or at least there will be a tilting towards you being granted leave to remain, because you would then be going to the Secretary of State saying, look, the appeal tribunal has decided that it's just not foreseeable within any reasonable timescale that it's not foreseeable that there will be a reason to believe that I'll be admitted anywhere within a reasonable timescale. Please give me a limited period of leave to remain. That won't necessarily.
I'm sorry.
Sorry.
I mean, if he wanted to be put out of his agony of indecision and know where he stood, what would be to stop him in this situation from voluntarily going to France?
Well, my understanding is that the views of his lawyers are that he simply would not be admitted to France at all, voluntarily or otherwise. And I don't know the details, but it's because of the period of time that's elapsed since he went from France, and that's why, as we understand it, the Secretary of State hasn't nominated France. But yes, absolutely, he could, as an exercise, on the basis of the advice he's received, he could, as an exercise, try to undertake some process of going back to France or Palestine, and then go back to the Secretary of State and say, look, I've made these efforts, they haven't failed, now consider my case. But the difficulty with that is that it would just be, he wouldn't necessarily, through that process, derive evidence that would persuade the Secretary of State to take one course rather than another. And that the whole issue of his returnability or admissibility even to another country wouldn't have been judicially determined. And on an appeal, if you do succeed, for example, on the basis that you can't be removed in accordance with the law, the tribunal probably wouldn't ordinarily exercise this power, but it would have, having heard submissions on the matter, power to actually make directions one way or the other, requiring the Secretary of State to take particular steps. So I'm not suggesting that to win an appeal would necessarily, in every case, far from it, require the Secretary of State to grant leave to enter or remain, but it would build up a stronger case and point towards that. As I say, in this particular case, he hasn't taken any practical steps because of the advice that he's received that he would not be allowed into France as a Palestinian and as somebody who has exceeded the time periods within which the sort of third country machinery sort of operates.
This is a Dublin agreement.
Yes, yes. That's my understanding, that his lawyers have taken the view that because of the time he's been in here, it is no longer possible for him to be returned through Dublin to France, and for the same reason that he wouldn't be admitted. And of course his claim has actually been accepted and determined, which under that machinery would knock out France as a possibility.
Just coming back to your challenge to the respondent's submission that it's a two-stage process.
Yes.
In one sense, surely, it must be, unless your contention is that it's for the immigration decision-maker to decide what aircraft or ship he should be sent back on, which is all part of paragraphs 8 to 10. I don't know whether you're going that far.
But I certainly accept that the process of removal is a two-stage process, in that inevitably there has to be a decision that, in my submission, is implicit in paragraphs 8 to 10, and then there has to be the action of giving removal directions.
And who gives those?
Well, that would either be the immigration officer under paras 8 and 9, or the Secretary of State under paragraph 10. So that would be a designated rank of officer within those two departments. And I think probably underlying your Lordship's question is the idea, which I'd accept, is that there, at that second stage of giving the removal directions, there might still be, if I can put it this way, sort of small matters of detail to decide. But my fundamental submission is that it's implicit under paras 8 to 10 that the decision to make removal directions is simply one straightforward decision to make removal directions, and that decision itself is nothing in the language of paragraphs 8 to 10 to indicate that decision itself is split into two stages. One, a decision to remove somebody from the UK in principle, followed by two, a decision to give removal directions to a particular country or territory, then to be followed on the Secretary of State's case. Thirdly, by the giving of removal directions where presumably there may also be some small matters of detail to be.
But you're not suggesting
out.
that the immigration decision maker, deciding whether or not the person concerned is a legal entrant, that person has simultaneously to decide whether to send the person away on a ship or an aircraft, and if so, which ship or which aircraft. That's done at a later stage, is that right?
Yes, I think that's right. Yes. But the decision that the Secretary of State would have to make implicitly under paragraph 10 is a decision to give the owners or agents of any ship or aircraft a direction requiring them to make arrangements for the removal of the person from abroad to one of the countries on this list. So I do submit that the decision in principle, if you like, that's made under paragraphs 8 or 10, clearly under this structure includes a decision that a person is to be removed to a country that satisfies the criteria in 8.1c.
Yeah, well, I follow that if I'm understanding you correctly, that you're saying the immigration decision maker must decide, among other things, where the person must be sent if he doesn't leave voluntarily, and that decision, if I understand you correctly,
yes,
must be a decision to send him to a country or territory falling within section 8.1c.
That is my submission.
Yes, if he gets it right, Is there any power later on to change it if circumstances change?
If he gets it,
Just take the
but,
present. Take the present case. If when the present case was decided, not these facts, I agree. It was perfectly clear that there had been absolutely no problem in your client going back to Palestine. But then somebody else has got to decide when and by what means he's sent back there if he doesn't go voluntarily. And then, which is not altogether unlikely, huge trouble breaks out there and there's no way he's going to get in. What happens then?
Well, in my submission, the Secretary of State would be entitled to rely on the provisions in the Interpretation Act 1978, which provide, and I can't recollect the precise section, which provide that where there is a statutory power, it can be exercised from time to time as the circumstances require. And in reliance on that, in my respectful submission, the Secretary of State, and in reliance on general public law principles, the Secretary of State would be entitled to rescind the immigration decision that he had earlier made on the basis that removal to Palestine would be lawful within paragraph 8, and to replace it with another immigration decision, which would of course be appealable.
Could you do that? The example I've given you is one where it was a perfectly sensible decision to where to send the person concerned at the time, but later turned out not to be. And as I understand it, you're submitting that in those circumstances it could be changed.
Yes, and vice versa.
What about the other way around, where it is a decision, which is your case, that Palestine is not a country that falls into any of the sub-paragraphs of paragraph C?
I do accept that.
Could the minister then rescind that?
Yes, the same approach would have to apply, and more particularly, the circumstances in which this might arise is where there had been a successful appeal, for example, by MS. He may have succeeded in his appeal on the facts as they were presented to the tribunal. On ordinary principles, that would then, in my respectful submission, preclude the Secretary of State from making exactly the same decision again if nothing had changed. But if something had arisen that put a different complexion on the facts, or if there were new facts that arose, then yes, on ordinary principles, the Secretary of State would then, notwithstanding the decision of the tribunal, be entitled to make an immigration decision involving removal to a different country, or even an immigration decision involving removal to the same country, because there'd been changed circumstances or something new that put a different complexion on the old facts. So, as ever, success would not absolutely guarantee that the person concerned could never be removed, which is why I said earlier that it would simply tilt in his favour as far as concerns how his case was to be disposed of by the Secretary of State, but it wouldn't paint the Secretary of State into a corner. All he wouldn't be able to do was directly contradict exactly the decision that the tribunal had just made.
But changes in circumstances in this area are frequent, and again, going back to Parliament's intention, Parliament must be taken to have understood that situations change. And the arrangement that you have suggested seems to me to be a very cumbersome and a much more obviously neat way of dealing with things, surely would be for the immigration decision to be concerned with the basics, that's to say, is this person an illegal entrant and should he be removed in principle? And then deciding the question, the practicalities of removal, including the paragraph 8.1c questions, but also the other questions like the method of removal and all the rest of it, a whole range of practical questions of that sort, which are surely most effectively dealt with at the time the decision is to be made and implemented, thereby reducing to a minimum the need for recourse to the courts.
The public policy behind the new appeal provisions has got quite a lot of different facets to it. And I'll try to address your Lordship's question directly. But at the moment, the submission that I'm making about the structure of paragraphs 8 to 10 is that on the basis of an ordinary approach to statutory construction, the immigration decision that's referred to in section 82.2h is the decision that's implicitly made under paragraphs 8 to 10. And the only decision that paragraphs 8 to 10 contemplate is a decision focusing on 8.1c, which is relevant to this case, is a decision that a person is to be removed to a country or territory falling within one of the specified categories. Now, if that is, as a matter of ordinary construction, the scope of the immigration decision, then, in my respectful submission, that is the answer to the case, irrespective of whatever particular view one might take about the convenience of it. As far as concerns convenience, though, I mean, there are issues going both ways, and there are features of the statutory scheme, which I'll come to later, for example, section 120, which on the face of them would appear to demonstrate quite a strong public policy in favour of the tribunal resolving all the issues that can be resolved at an early stage. And the question that arises under 8.1c is a question that can be resolved at the time of the appeal hearing. The threshold is quite low. All the tribunal has to do is ask whether there is reason to believe that somebody will be admitted to a particular country at some point in the future. Now, where there are, as your Lordship has just put to me, where there are practical difficulties and where there is a state of flux, then the tribunal will be perfectly entitled to form the view that there is reason to believe that somebody will be admitted to a particular country or territory at some point in the future. They could take that into account. So the sort of practical considerations that your Lordship is putting to me are sort of catered for by the lowness of the threshold here in paragraph 8.1c. The Secretary of State and the Tribunal would not have to rebut every small or even large practical problem that was raised by the person from abroad. There would have to be something pretty fundamental. And in this particular case, and one accepts that for various reasons it wasn't dealt with, the argument was that fundamental. His argument was that it is impossible. And practical problems can come and go, but the impossibility of MS getting removal documents was put forward as something that was pretty permanent.
Well, there may be. I mean, it seems to me this generates huge uncertainty, because if the Secretary of State and on an appeal the tribunal is going to have to decide whether within a reasonable time the situation will be such that 8.1c is satisfied. It's going to have evidence about that. How long is a reasonable time? It's all very uncertain. I mean, I know I keep going on about the practicalities, but one trying to look for something sensible.
Yes.
And I just question the utility of a decision which is based upon this low, as you put it, this low threshold, when what really matters is whether when when the decision actually has to be made to remove, whether at that point in time it can be carried into effect. And what is the purpose of saying at some time, at some earlier stage, well, there is a reasonable possibility that this threshold will be satisfied at some reasonable time in the future? I mean, what purpose does that really serve?
Well, I think the first issue that Your Lordship raised was the practicality of looking at the evidence relating to whether or not somebody would be admitted across the border. And if one, I'm not going to turn it up, but if one looks at this particular case, in order to deal with MS's Refugee Convention and Human Rights Convention claims, the tribunal looked at a range of evidence about circumstances in Palestine, and I'm sure it's the experience of all members of this court looking at these types of decisions, that the tribunal will be looking at country reports that deal in great detail with what happens both within the country and also at the border, because there's been a stream of cases involving Palestine where it's been alleged that ill treatment and abuse has actually taken place at the border. So that's sort of common enough area of investigation for the tribunal. And if one looks at this particular tribunal decision, without any objection from the Secretary of State, the tribunal also considered a case, it's a tribunal case, a country guidance case, which I think is called MA Palestinian Territories, which established as a country guidance case that enforced removals to Palestine where impossible. And I think that's not in accordance with the Secretary of State's current thinking, but that's the type of issue and the type of evidence that the appeal tribunal does commonly look at. And one can view it both ways, but in response to my Lord's question, my sort of submission in response to that is that actually one could argue that it's sort of faintly surprising that when a tribunal spends so much time and trouble looking at evidence about circumstances in Palestine and at the borders of Palestine, why it doesn't, having swallowed the elephant, go on to look at the associated ancillary questions of removability under paragraph 81C, since it's doing that job. Why wait months or years down the line and put that job in front of an administrative court judge who isn't a specialist fact-finding tribunal, when there is not just a public interest, and I'll come on to that later, but an interest, a legitimate interest in the appellant to have the issues raising in his appeal determined one way or the other. But leaving aside the policy, I thought it was very unwise to mention policy right in my very initial submissions.
Well, as a matter of statutory construction.
There's a matter of statutory
As a matter of statutory
my lady.
construction.
There is.
What is your argument for saying it's possible to separate the question of the destination in paragraph 81C, as applied by paragraph 10, from the question of the means? Because they're all one thing. These directions are very specific. They're go by this means to that place. Not only that, of course, they bring with them the right to use coercion, which is sitting there in paragraph 11. Now, what's your foundation for separating, as I say, destination from means as a matter of construction? Other than that it suits your case.
Well, because of the language of 10.1, where when the conditions in little a and little b are satisfied.
But he's still got to give directions to the owners or agents of any ship or aircraft, such as are authorised by paragraph 81C. The two, they're all wrapped up in a single sentence.
Well, the decision that's required to be made in my submission is a decision to give the owners or agents of any ship or aircraft, quote unquote.
That happens to be going there.
Well, it's simply any ship or aircraft.
But that's not what happens. The directions actually specify exactly which you should get, surely.
That is right when one gets to the removal direction stage. But the ambit of the decision that arises by virtue of paragraph 10 is a decision. If one puts oneself in the shoes of the Secretary of State, I have decided I will give the owners or agents of any ship or aircraft, doesn't matter who they are.
No, that isn't how that works, is it, Mr. Naffler? That's not how that works. The Secretary of State gives directions to the particular owners of a particular ship or aircraft, or maybe of
Oh, no, absolutely.
saying, you are off to wherever you're going, and you must take this bloke with you.
Yes, I didn't mean to suggest that that isn't how things happen when removal directions are made. When removal directions are made, they are specifically directed at the owners or agents of a particular ship or aircraft. Absolutely.
But your case is that it's not possible to give directions to any ship or aircraft. I mean, I think the reason why we end up on focusing on a particular country is that that's actually, at least in the present case, well, I think because of the regulations, in any event, an absolute requirement which you can therefore specifically say is there, has been identified and can therefore be challenged.
Yes.
Otherwise, I mean, if the matter were more open and there were a possibility of applying not Regulation 10 but Regulation 8, A, B or C, you'd have to, on your case, you'd have to exclude any of them applying or exclude all of them. But as it is, you're able to focus on one feature which you say is there.
Yes.
But I mean, the real trouble is that, as you yourself accept, it's only there in a rather preliminary and vague way, at a low threshold. And I think the threshold, in fact, is even lower than you state, isn't it? Because the threshold you've been talking about, reason to believe you'd be admitted, is the one which applies at the date when the removal directions are given. At the present date, we're concerned with the question whether the Secretary of State, when he proposed Palestine, which is all that the regulations refer to, the country to which it's proposed to remove the person, whether he could bona fide, possibly reasonably, propose Palestine on the basis that he had reason to believe that in future he might have reason to believe.
Oh, yeah, no, that is my submission.
Yes.
But the question is...
I mean, there might be absolutely no prospect of the chap being admitted now, but the Secretary of State might say, I'm sorry, I believe that I should be able to go and speak to my Palestinian homologue, and we give them a lot of funding, and we think you'll see reason. And that would be quite sufficient at this stage, wouldn't it?
Yes, and that is not only my submission,
On your case.
but that is, in a sense, my answer to the concerns about practicality and waste of time. That it's only in a very, very clear case that a person from abroad is going to win an appeal that turns on the applicability of 8C4, because he's going to have to establish, to the satisfaction of the tribunal, that at that time there is no reason to believe that he will be admitted in the future when the Secretary of State ultimately gives removal directions to the nominated country or territory. So he's only going to succeed in a case where it's very clear that there is no realistic possibility, to paraphrase Little 4, in the foreseeable future, that he's going to be admitted, either for legal reasons or for practical reasons. And that's how MS put his case, that it was just impossible to conceive that within any realistic timescale he was going to be admitted to Palestine. That it's only those very rare cases that are going to succeed, and therefore the sort of run-of-the-mill case where there might be, as your lordship has put to me, in the run-of-the-mill case there might be all kinds of arguments about what might happen in the future because of various practical difficulties. That's simply not going to...
But bearing in mind that even at the removal direction stage, you're only going to be able to challenge by way of judicial review, I think on your own argument, if there's absolutely no prospect, no reason to believe that the man will be admitted. Isn't that a pretty good safeguard at that stage?
Well, it's exactly the same safeguard.
Well, it isn't actually. I think it's a more. I'm suggesting to you that it's a more remote safeguard because we're now one stage back and we're concerned with a question now, a proposal now, which relates to a possible future situation, and the question whether in that future situation there may be reason to believe.
The legal test is the same, but it might be easier for the person from abroad to satisfy it at the judicial review stage. That's absolutely right.
Is it part of your case, which as I understand it, the immigration decision maker must indicate a country, or the country or territory to which this person should be removed, compliant with paragraph 8C 1 to 4, that the decision maker must give reasons for that choice?
Well, it is, and the easiest way of dealing with reasons is to look at the notices regulations, which contain a requirement both to give reasons and state the country or territory of destination. And I do propose to come to the notices regulations fairly speedily. But at this stage, I mean, leaving aside for one moment, if I may, practicality, public policy and all the rest of it, there is a question of law here, if I may respectfully so submit, which is what is the ambit of the immigration decision referred to in section 82(2)h. To understand that, one has to look at paragraphs 8 to 10 of Schedule 2.
Well, that was why I was putting my question to you, because if you want to bring those paragraphs into the ambit of the decision, it's quite hard to work out why you just pick the bit you like.
No, well, I'm trying to have another crack at answering your ladyship's question. And in my submission, it might be easiest to confine my answer to the facts of this particular case. This is a case which has proceeded throughout on the basis that we're a paragraph 10 case. So it's easiest just to look at what decision is required in a paragraph 10 case. And in my submission, the decision that's required is a decision looking at reading past 10(1)A and B to the two lines after that on page 40. The decision is a decision to give to the owners of any ship or aircraft any such directions as are authorised by paragraph 8(1)C. And I suppose the submission I've been making is that this requires the Secretary of State to really decide two things. One, that there is in existence the owners or agents of any ship or aircraft, which is just obvious, and then to decide whether there are any directions.
Well, there are some places it's just not possible to get to.
Yeah.
Physically possible.
Well, yeah. That would be one very clear example. Yeah. But the next question for him is to ask himself, and then the question for the tribunal is whether there are any directions in respect of that person that are authorised by paragraph 8(1)C. I mean, he just has to, in my respectful submission, under this structure, confront that decision. I mean, the question of whether or not there are any owners or agents of any ship or aircraft is an obvious question to answer. There always will be. The question of whether or not directions are possible under 8(1)C is ordinarily a very easy question to answer, but in some cases not so. And as your ladyship has just pointed out, there will be, in some cases, only one country candidate, and it will just be obvious that the person cannot be admitted to that country. But that's precisely the sort of case that we say falls within the appeal provisions. And it's precisely that sort of case that is the only sort of case that will appeal, that will succeed.
Well, what sort of directions do you say do not, on your interpretation, do not fall within the immigration decision and therefore liable to an appeal, but are removal directions properly so called and which could only be challenged by judicial review? I'm really struggling at the moment to know where you draw the line and why you draw the line where you draw it.
Yes,
I
great.
think my lady's question was directed in a way to where you draw the line and why you draw it where you do. But I mean, you do accept, I think, from your case, your written case, that there are certain directions which are not susceptible to appeal because it's common ground that in fact you can't appeal removal directions. And I'm struggling at the moment to know what it is which falls within paragraph 8, which, on your interpretation, is properly characterised as a removal direction and therefore not subject to an appeal.
It is common ground that removal directions are not subject to an appeal. And the reason from our perspective that is common ground is because on our case, the appeals machinery that one finds in section 82 and section 84, but particularly in section 82, takes a course which is rather different from the course that had been taken in earlier legislation, and it draws a clear distinction between decisions which are appealable and other matters that aren't. And it's because the giving of removal directions manifestly is an action and not in itself a decision. It's because of that the removal directions cannot be appealed. So one then has to look back at the 1971 Act to try to disentangle the unappealable act of giving removal directions from the underlying decision that a person is to be removed in accordance with paragraphs 8 to 10. And that's not easy to do because the 1971 Act doesn't itself expressly set out in paragraphs 8 to 10 a sort of decision-making machinery. So one has to read paragraphs 8 to 10 to try to understand what is the ambit of the decision that is impliedly required to be made, because that is then the immigration decision that is appealable, as contrasted with the act merely of giving removal directions that isn't. And what we say is that if one looks at paragraphs 8 to 10, and this is reinforced by paragraph 16, which we haven't had time to get onto yet, that the nature of the decision, the ambit of the decision that's required to be taken on the face of it is a decision to remove somebody in a paragraph 10 case in accordance with the detailed requirements of 8.1c. And we say quite simply, well, that's part of the decision. It may well be that, as was put to me by my Lord Savile, that it's impossible, reading paragraphs 8 to 10, to absolutely draw a dividing line between discretionary judgments, discretionary decisions on the one hand, and the practical giving of removal directions on the other hand. It may well be that when ultimately removal directions are given to the carrier, there remain some matters of detail that someone has to make a decision about. But reading paragraph 10.1 in my respectful submission, the ambit of the decision is absolutely clear, that it is a decision to remove somebody not just from the UK, which is the language used in paragraph 81A and 81B, but to remove a person to a specified type of country. That is my respectful submission by definition, as it were, all part of the immigration decision. And that is reinforced if one goes to, and I'll just make this point very briefly, if one goes to paragraph 16 of Schedule 2, one comes here across the only reference at all in Schedule 2, possibly in the whole of the Immigration Act, certainly in Schedule 2, to a decision being made. It's focusing really on the liability of people to examination or removal. 16.1, person who may be required to submit to examination under para 2 above may be detained under the authority of an IEA pending his examination and pending a decision to give or refuse and leave to enter. Then at subsection 2, if there are reasonable grounds, and this marries up with 8C14, if there are reasonable grounds for suspecting that a person is someone in respect of whom directions may be given under any of paras 8 to 10A or 12 to 14, that person may be detained under the authority of an IO pending A, a decision whether or not to give such directions, and B, his removal in pursuance of such directions. And we say that paragraph 16.2 is significant because it divides up the functions under paragraphs 8 to 10 in a twofold way. One, there is a decision whether or not to give directions that are permissible under paragraphs 8 to 10, capital A, 12 to 14, and then removal in pursuance of such directions. And what it does not do, and there may be frailties around the edges of our argument, but what paragraphs 8 to 10 and 16.2 emphatically do not do, in my respectful submission, is provide any warrant for the Secretary of State's submission that there is a threefold decision-making process of decision in principle about removal from, followed by a decision about removal to, which could be years down the line, then followed by removal in pursuance of directions. It's clearly just a two-stage process, and so the ambit of the decision referred to in 82.2h is a decision, as 82.2h suggests on its face, is a decision that a person is to be removed in accordance with paragraphs 8 to 10. If that person raises a argument that they cannot be removed under paras 8 to 10 because they don't fall within those provisions, then manifestly, in my respectful submission, that is not a decision that is in accordance with the law in the sense of the Immigration Acts, let alone public law.
Am I right in thinking there's no separate right of appeal from the rejection of an asylum or human rights claim? It's only against the removal decision.
That is absolutely right, and that's a point I made very briefly, I think, looking at Section 4 and parts of Schedule 2, and that's a really important point in my respect submission when one comes on to look at the notices regulations, which are my next point, because what we say about the notices regulations is that they actually define in terms what the immigration decision is in such a way that it is clear, really beyond any realistic doubt, that an integral part of the immigration decision, all of which is appealable, is the decision that a person is to be removed to a specific country. That is put there in the notices regulations to tell the person where he is being removed to, and by making that part of the immigration decision, to give a right of appeal. I don't know if that would be a convenient point for the court.
Yes, of course. 2 o'clock, please.
Thank you.